Welcome to the video lecture on Chapter 1, which is kind of just an introduction to the law of evidence and the pretrial process. So first things first, we want to define evidence. And so evidence is any information about the facts of a case that includes tangible items, testimony, documents, photographs, or recordings. And when we use evidence, we present it at a jury trial, and it is used because it tends to prove or disprove the facts of a case. And I'll go ahead and note really briefly that testimony here is the most common form of evidence. So the technical definition of evidence is that evidence consists of testimony or physical items presented to the judge and jury that they use to decide the truth of an assertion, the existence of a fact, guilt or innocence of the accused of a crime. So evidence can be used for each one of these. It does not have to be like a red herring or a smoking gun or even a definitive 100% sure that this piece of evidence is going to be the deciding factor. It just needs to sway the judge or jury on one of these three issues. A really important concept in this chapter deals with the chain of custody. And the chain of custody is a process, and it is how the evidence is handled, by whom handles the evidence, and the accounting for the evidence's whereabouts and conditions from the moment it is found until the moment it is offered into evidence. And generally, no item of physical evidence could be introduced at a trial unless the law enforcement officer has maintained the proper chain of custody of the item. So it's really important. And if we think about maybe some contraband, some drugs, particularly maybe heroin needle, that needle would need to be documented, where it was found, who found it, how it was handled and removed from the scene, where it was stored, whether it was tested by anyone in a lab, the results of that, when it came back from the lab, who took account of it, and how it was then stored, if a prosecutor came to see it, if a defense attorney, so all of those types of things would be documented out in the chain of custody. And without that, it cannot generally be introduced into evidence. So there are a bunch of different ways to think about evidence, just because evidence is really broad. Evidence can be real evidence, demonstrative evidence, direct evidence, circumstantial, physical, intangible, and scientific. And your book does a really great job of defining kind of giving you the brief information of what each of these types of evidence looks like. So the rules of evidence. These are a set of regulations that are a guide for judges, attorneys, and law enforcement who are involved in the trial of the case. The rules of evidence determine how a trial is to be conducted. So sometimes it puts together a time limit. Certain things have to be filed so many days before trial and things like that. It indicates which persons can be called as witnesses, the matters that they can testify about when they're on the stand, how articles of the crime scene are collected and preserved, and what can come into a trial and what cannot. So the rules of evidence are really important, and even though they're used in the courtroom, we need everyone to be aware of them before then, because if evidence is handled improperly by law enforcement officers, then it cannot be used at the trial, which possibly means we cannot get that conviction we're looking for. Or from a defense attorney perspective, it's a great thing because maybe you get a better outcome for your client. I will not spend a lot of time talking about the history, but there is a section of the book on that, and it's pretty interesting. So as we move through the kind of the history, Originally, a small jury known as the petite jury was selected to try someone who was accused of a crime. And the petite jury was only those individuals who had personal knowledge about a case. And then witnesses who had information were then called to testify, which is really different. Around 1700, trial by jury had become more of a reality, and that was characterized by swearing in witnesses, cross-examining the witnesses. Hearsay evidence started to disappear from trials, and the rules of evidence began to develop. So as the rules of evidence started to develop, it's really important to know kind of the general purpose of the rules of evidence. The rules of evidence are designed and intended to keep some relevant information away from the fact finder, even though it's relevant to the trial. Some information, if given to a jury could violate a constitutional right, or a principle, or something that we hold dear as a society. And evidence that has been obtained by a law enforcement officer a judge may have determined that it violated a suspect's constitutional rights. So we're going to keep that out to protect the Constitution. But again, the main goal here is that even though some information is relevant, we're not always going to let every single thing into the jury because it may not result in a fair outcome. The rules of evidence in most jurisdictions are either in a statute or code. Most states have codified a version of the federal rules of evidence. The federal rules of evidence are used in all federal courts throughout the United States, and 43 states have relied upon them as a model in creating their own evidence code. But we're going to go ahead and note that each state does have its own code of evidence. Because the primary framework is the federal rules of evidence, that's what we're going to kind of focus in on. Here we list a state the states that don't have the federal rules of evidence. You can see Indiana's not in a list, which is again another reason why we're going to focus on the federal rules. Federal rules of evidence apply both in criminal and civil cases. And in the criminal justice system, the federal rules of evidence covers observation or report of a crime, investigation of the crime, the arrest, prosecution, trial, sentencing, appeal, service of a sentence, and release of an individual from custody. So the federal rules of evidence intersect with the criminal justice system throughout the entire court process, which is why this class is actually super helpful. As far as the role of law enforcement, we have kind of the main functions of law enforcement: to enforce the law, to maintain public order, and to provide public service. There's also federal law enforcement. We have the FBI, we have drug, alcohol, tobacco, and firearms, drug enforcement. So there's all these different layers of law enforcement. And larger agencies often employ specially trained and educated personnel who are familiar with fingerprints and bloodstains and DNA and scientific methodology and ballistics, because those things are so pertinent to obtaining conviction. Also, depending on the type of case, other law enforcement officials might be involved, such as investigators who are not employed by the police department. We're going to have courtroom personnel, we're going to have jail personnel, prison personnel, or probation officers also involved. As far as the prosecution and the defense attorney, it is the job of the prosecutor to pursue a case developed by the police until the case terminates by trial, guilty plea, or dismissal. Decide whether to pursue a formal charge or not, and what crime to charge. Again, this is really within the prosecutor's hand whether or not to issue a formal charge, if you think back to your introduction to courts class. Prosecutors are also going to conduct both sides will engage in plea negotiations, and ultimately through that decide whether or not a case will go to trial. Defense counsel is going to zealously represent the criminal defendant from the point of interrogation through the trial process. The goal is to demand the prosecutor respect the defendant's right and meet the burden of proof. And if we think back again to courts one more time, remember that we do have the dual judicial system, so we do have the federal and the state courts, which are coexisting. Because of that, though, remember jurisdiction is the court that has the power and the authority to try the case within it. For our purposes, thinking of criminal law, it's often state law, and these are often going to be handled in state courts. And thinking about this, venue versus jurisdiction. Venue is the neighborhood, place, or county which an act is declared to have been done or happened. So this is the geographic area which a court with jurisdiction may hear and determine the case. But jurisdiction is the power of the court. So those are just some terms to kind of remember and think through. Now, lastly, the Bill of Rights, our constitutional rights, are going to intersect with federal rules of evidence. In particular, the Fourth Amendment has protection against unreasonable search and seizure. The Fifth Amendment is privilege against incrimination, double jeopardy, the right to take the Fifth and not talk. The Sixth Amendment guarantees defendants a right to a jury trial, compel witnesses, confront them, a speedy trial. Eighth Amendment is freedom from cruel and unusual punishment. The 14th Amendment provides protection from racial and sexual discrimination. So there's all these different intersections of law. So for this chapter, I really hope that you just work through all these different intersections and kind of refresh your memory that you probably got in criminal law or courts, whichever class you took before this. This chapter does a really good job of kind of running through the entire process, and the next part would be looking at probation and parole, the difference between. So probation is pre-sentence and the end of the year, whereas parole are those who are released before their full prison sentence expired. Something to kind of focus in, because we're going to be talking about these issues for the rest of the semester, is the pretrial court process. So that is the arrest, bail, plea bargains, the charging of the crime, the arraignment, and the defendant's initial plea, and pretrial motions. So the first thing we need to make sure exists is that there was probable cause, that an officer has enough evidence to lead a reasonable person to believe a crime has been committed. So that has to exist. After that, the law enforcement officer is going to file a criminal complaint with an affidavit sworn under oath about their information. Then suspects might be released on bail, depending on the offense. After that, plea bargaining will occur, and it may be an ongoing process even throughout the arrest. Then we will have a preliminary hearing where the judge decides whether there is enough evidence that the accused person committed a crime to move forward in the process. At this point, the prosecutor is likely to have at least one law enforcement officer take the stand. After that, if we are in federal courts, we're going to have a grand jury and an indictment. In state courts, we have an indictment. We're going to have our arraignment where the defendant gets to enter their plea. And any pretrial motions may occur to suppress evidence, for discovery, to change the court, whether or not the defendant's competent, whether or not we need experts, even to dismiss. So at this point, law enforcement is still going to be involved in many different ways. They're still going to continue to investigate the case, often up until the time and even during the trial. And law enforcement needs to have their reports in good order and familiarize the reports with other law enforcement. And they also are going to need to be aware of just kind of some of the basics of like you to focus on.